All right, welcome everybody. We might as well get started. So, my name is Shea Brown. I'm the CEO and founder of BABL AI. And this is really just a sort of impromptu, casual conversation that we plan on having every week, talking about algorithmic auditing, bias audits, risk and impact assessments, and responsible AI in general. This is the first one we're having. So now is the time to talk about New York City Local Law 144. And so that's mostly what I'm going to be talking about today. And feel free. It's just me. I don't have my team with me. And so if you've got questions for me, I'm gonna present some things. I'm gonna talk. This is really going to be free form, me thinking about these issues and talking through them. And if you've got questions, feel free to put them in the Q&A, and at the end, I'll go and look at those and address those questions. So what I'm going to first do is share my screen. So hopefully everybody can see that. So we're going to talk this first one. And by the way, the Lunchtime BABLing was our COO, Ben, came up with this phrasing, which is good on him. I think this is nice. So this first one, we're going to talk again about the New York City Local Law 144, which is the law that is going to require, among several things, bias audits for disparate impact for any automated employment decision tool. And the reason why we're starting out on this, and we had already had a webinar about this earlier, is because there are some new rules that have been proposed, and there's a lot in there, and there will be comments, a comment period. BABL will submit comments next week, and there'll be a public hearing, and we will talk. But there's so much to unpack that I felt like it would be great to just get started on this conversation. And part of the reason is that this is coming up so quickly. And so here's a quick outline. I'm going to just, for those of you who haven't heard about this law or don't know about this law and are just here to talk about sort of AI ethics or responsible AI in general, I just want to give you a little bit of a summary of what this law is and what it means. And then I'm going to go into the new rules and talk sort of at length through some of the proposed clarifications. And I'll give you a little bit of my opinion. We'll have official comments next week, but I'll give you sort of my quick take on some of these things. And then there'll be sort of a Q&A session where I'll just look through your questions and try to address those. So a quick summary of what this law is. So essentially the New York City Council passed a law which will require anyone who's using an automated employment decision tool, and I'll get into what that is more in a minute, in New York City or on candidates that reside in New York City, they have to have some obligations. And so the obligations are the duty of the employers and employment agencies. And this is a relevant distinction because most of these tools are actually made by sort of external vendors, but it's the employers themselves, the people who are looking for the candidates or making promotion decisions. They're the ones who have to adhere to this law. And what is required? Well, there are several things. One is an independent bias audit of the tool. So the bias audit really focuses on disparate impact or adverse impact, among other things. And it has to be done every year. And you have to put a public summary of that bias audit. It has to be made public. It can't just be sitting somewhere where no one can see it. They're making people make that public. And then there are a number of candidate notifications. So you have to let candidates know this AEDT is being used and allow them the ability to opt out of that. We won't be talking about this as much because BABL is a company that that audits algorithms for bias and disparate impact, as well as ethical risk and good governance. And so that's really where our expertise lies, and that's where I'm going to focus on. When is this required? Well, part of the urgency of this whole thing is that it's January 1st, and this is not very far away, especially those of you who may have done these sorts of audits before. It's not a small task, and so there is not much time for those who have not started on this journey. Penalties are relatively small, up to $1,500 per violation per day, but the violations are every little subparagraph of the law. If you don't adhere to that, that's an independent violation. So at scale, this could potentially be quite a bit. And the enforcement agency is the New York City Department of Consumer and Worker Protection. So that's the basic summary of what this law is. And if you're here, probably a lot of you have actually thought a lot about this or heard about this. And so what I want to talk about now is what's new, what's going on with these new proposed rules. So they already had one session where they proposed rules, which were basically just the penalties that I had just mentioned. And there were comments that were submitted at that time. BABL submitted comments among other groups. But this is the first sort of substantial rulemaking where they've attempted to clarify some of the terms and address some of the comments that came in originally. And so next week will be the hearing on this. So here's the original definition of what an AEDT is. So this is what I'm going to start with first, because I think it's fairly impactful, the changes. So the way they define it in the text of the law is any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified output, including a score, classification, or recommendation, that is used to substantially assist or replace discretionary decision-making for making employment decisions that impact natural persons. Okay, so there's a lot to unpack here. It's got to be a computational process, and then derived from machine learning, statistical modeling, data analytics, and artificial intelligence. And so that's something that they attempted to clarify. This idea of substantially assist or replace discretionary decision making, that's also something that they attempt to clarify. So this is now new. This is from the new rules that they are proposing, where they clarify that the phrase to substantially assist or replace discretionary decision making means to rely solely on a simplified output. So like a score, tag, classification, ranking, etc., with no other factors considered. Okay, so that's number one. So this is just an automated system where you have this simplified output, and you're relying solely on that. So this could be a case where you're just filtering people immediately out of your system based on these with no other factors considered. So it's just the sole filter. Or to use a simplified output as one of a set of criteria where the output is weighted more than any other criterion in the set. Okay, so this now allows for perhaps this AEDT gives you some sort of simplified output, some sort of tag or score or classification, and that's just one of many that you use to make some automated decision. Okay, in this case, what they're saying is the simplified output from the AEDT has to be weighted more than any other of the criteria. Okay, so this is now starting to narrow things down a little bit. Let me keep going, and then I'll talk about a little more generally. Or to use a simplified output to overrule or modify conclusions derived from other factors, including human decision making. So here, this is they're explicitly including cases where you have an output which will inform what a human will decide. Okay, so it's not some automatic filter, but it will inform how humans make the decision. And in this case, I think a lot's going to rely on this term modify. Overrule is fairly clear. if it sort of overrules something, then it is fairly straightforward that it's essentially automatic. But modify is different. How much do humans or a hiring manager, let's say, take these outputs into consideration? And I think this is a place where there will be quite a bit of gray area. So let me move on, and I'll come back to some of my main points for this section in a second. They also try to clarify what they mean by machine learning, statistical modeling, data analytics, or artificial intelligence. So here they say it means a group of mathematical computer-based techniques. So this is something, a computational process that so there's going to be three of these. One that generates a prediction or a classification. Okay, so prediction or classification, including assigning candidates to some group or categorizing them in some way or measuring some probability of their fitness for the role or something like this. So this is fairly straightforward, something that provides a prediction or a classification. So the important bit here is that that's not the only criterion. And for which a computer, at least in part, identifies the inputs, the relative importance placed on those inputs, and other parameters for the models in order to improve the accuracy of their prediction or classification. Okay, so now they're really honing in a little bit on a very particular type of automated process where they're essentially saying the algorithm or the computer is going to identify, let's say, relevant inputs in an automated way, figure out the relative importance. So like this is essentially talking about weights for inputs and other parameters for the model to improve the accuracy. So they're really talking here about learning. I think it's obvious that they're focusing on some sort of learning procedure to make the predictions more accurate, better in some way. And then there's an and as well, for which the inputs and parameters are refined through cross-validation or by training and testing data. Okay, so again, this is they're setting their eyes pretty squarely on machine learning. I think in my mind, that's what they are proposing here. And so my initial thoughts on this, and this is my hot take on it, and I'll emphasize I'm not a lawyer. This is something, there's sufficient gray area here that you should be talking to your lawyers about these issues, because this clearly is not settled, and it's not obvious what a lot of these things, the implications of a lot of this. But here's my general take, is that this does seem to narrow the scope quite a bit. The new rule could significantly narrow the scope of what counts as an AEDT. Essentially, if it's not something that is learning, given all of the ands in the previous two slides, that you could imagine there's room to argue that your AEDT is out of scope. And I think this is something that needs to get clarified, because either that's what they mean and they need to come out and just say it very plainly, or that's not what they mean and that things need to be adjusted. The language needs to be adjusted, because the way it's currently written, it really does seem to focus on learning, and that's sort of my point number 3 here, is that's clearly what this is pointing towards. Another thing that is, and I'll come back to that in a second. Another thing that's quite interesting that is this idea of decision augmentation. So, I mean, in the wider field of people thinking about regulations and AI governance, there is this idea of automated decision augmentation system. Instead of an automated decision system, many of these systems are used to augment decisions that humans make, and this is a very forefront kind of field of research for understanding what the implications of that are. I mean, a lot of what we do at BABL when we do risk and impact assessments is figure out this exact issue. Like, does it mean when someone interacts with an AEDT or an algorithm, full stop? How does that influence the decisions that they make, and how does that lead to risk, and how do we mitigate that risk? And so this idea of modify, which is it's one of the ways in which an AEDT could count, or an automated tool could count as an AEDT, is that it significantly modifies the decision that a human makes. And that's something that has to there has to be a lot of thought into whether your tool or any tool is actually modifying the decisions that, let's say, a hiring manager is making, or someone who's interacting with this system. And so, caution there. And I can talk forever about this, so I won't. Let me move on to another thought I wanted to say about this learning, because I think that they're missing out on a lot of there are a lot of algorithms that could potentially be excluded that I don't think are meant to be excluded. So I don't know how many of you do machine learning, but there's an algorithm called K nearest neighbors. And it's the simplest algorithm. And if I had a pen and paper here, I'd draw you a picture of it. But essentially, it's just a collection of data, which has been labeled in some way. It doesn't have to be what they call supervised learning. It could just be a collection of all your employees, right? And maybe you have somebody has labeled some employees as being quite effective, right? And so it's just a collection of data. It's just sitting there in a database, and they even sort of excluded just collections of data as a tool. But there's a computational process you can use to compare, let's say, a candidate with the people in your company. And so let's say you get features from that candidate, and you have the same features. Maybe it's an assessment or something, a test that they took, or something else, and you can compare using K nearest neighbors, basically, who are the closest people in that parameter space to this candidate. And K is just a number that you choose. Now, if you were to just choose that number, there would be no learning process going on. You just say, take the 12 nearest people in that parameter space to this new candidate in my company, and look at whether those 12 people on average were classified as being good employees or not. That is a fairly straightforward non-learning process in the sense that they are describing the learning, where there's no cross-validation. You're not using the computer. I just chose the number 12. However, that can be extremely biased. That is learning from past data, so it's considered machine learning, and under the current language that would be excluded. And so I think that some thought has to go into whether they're capturing with this more specific language what they actually think they're capturing. So anyway, I'm just going to stop there for that, and you can just think about what that might mean for you. Okay, so another thing that they have clarified is what is a bias audit. So this is the original definition from the law. A bias audit is an impartial evaluation by independent auditor. So, this bias audit should include essentially testing for disparate impact or adverse impact of any persons in component 1 category. So this is the sort of EEOC, Form 1 components. So this is race and gender. And that's it. So what they have sort of, and there are a lot of comments like you need to talk about what a bias audit is. We, in fact, were one of the groups that said that you have to be more explicit, and say that. So they were, and I think this is a good thing that they're more explicit. So the new language says that where an AEDT selects individuals to move forward in the hiring process or classifies individuals into group, a bias audit required by this code at a minimum must calculate the selection rate for each category, calculate the impact ratio for each category. So they're just spelling out the fact that you have to do some calculations. Those calculations have to be selection rate where it can be, and calculate impact ratios where you can. And where an AEDT classifies individuals into groups, the calculations must perform each for each such classification. So you have to do this for all the classifications you have. So they give an example, which is great. An employer wants to use an AEDT to screen resumes and schedule interviews for a job posting. To do so, the employer must ensure that a bias audit was conducted within a year from the use of the AEDT. So here they're just spelling out the fact that, remember, this has to be done within the last year before you even use it. The employer asks the vendor for a bias audit. I'll come back to this in a second. The vendor uses historical data that's collected from employers, and that's plural there, on applicants selected for each category to conduct a bias audit as follows. And so this is the example they give. And here I've rewritten this. It wasn't in a format you could just copy and paste. So this is a table that I've written. But these are the actual numbers that they have. And so what you see is they have split this out, and they have a column for gender. They've got a column for race and ethnicity, number of applicants, number selected. And from that, you can calculate the selection rate. And then the impact ratio is the selection rate divided by the highest, or the advantaged group, which is the highest selection rate. And you can see those on the right. One thing to note, the way it's currently displayed here, and I don't know if they intended this is on an intersectional basis. And so that's not typically how this is done. And I'm not 100% sure whether that was on purpose or not. Maybe it was. But this is on an intersectional basis. So normally it would be take all of the, so this is, unfortunately binary gender, but so all male and all female, and calculate the impact ratios for those groups total. And then the same for race and ethnicity. They do it separately. They don't do it on an intersectional basis. But in any case, that's what they did, and these are the numbers that they showed. And then they further give another example where an employer uses an AEDT to score applicants for culture fit. So to do so, the employer must ensure that a bias audit is done. So this is the same thing. Make sure you do this bias audit. The employer uses historical data on average culture fit score. So this is the case where you don't have a pure selection rate. So this might be where this number, this culture fit number, significantly modifies a decision that a human makes, a hiring manager, let's say. And so it falls under the law. However, it's not automatically filtering out. And so what they're saying is use a score itself for each category. And so this is what it looks like. Where it looks, you have the same categories here. You've got gender, race, and ethnicity. And then average score for this culture fit. So maybe this is a percentage, or it's not a percentage, it's just a number. And then that average score, so you take all the candidates, let's say, who are Hispanic or Latino male, and take all of them, and you average out their scores, and it's 76. Okay, so that's what that number means. This column was not in the original, the number of samples, and this I put in. And I'll tell you why I'm putting this in by hand. So I just want to point this out. This is not in the new rules document. This is something that I put in. I just put it in all hundreds. But from these average scores, you can calculate an impact ratio, and they give you the formula for it's literally just dividing the score, the average score itself, by the highest average score. Okay, so 86 was the highest average score, so that's impact ratio of 1, and then the rest are lower. There was a tie because it was 86 as well for the bottom entry. And so they're clarifying that you can do it for a discrete continuous score, as opposed to just a binary selection rate where either you got through or you didn't. So I just want to point out a few things. So again, this is my sort of hot take on this. I'm not sure that the intersectionality was intentional, and I say that because when they in the original law and even in the proposed rules, they do mention, they refer back to the uniform guidelines, the section where they talk about adverse impact, and those guidelines and they say do it in such a way as the guidelines tell you to do it, and that's usually interpreted in the non-intersectional way that I mentioned before. So that's something that needs to be clarified. It could be that this is a new, that this is something different, and they actually intended that, and we'll find out hopefully next week. The other thing is average score versus binning. So here that you can calculate this disparate impact, or the impact ratio rather, using the average score as they showed, but you could also bin it. And this is something that we, I think, encourage our audit clients to do, is to make a decision, what score is relevant, above what score would you consider someone getting an advantage or getting disadvantaged if they have a score below that. And so then you bin it up closer to a selection rate. And that's something that takes a little bit of investigation and normally a risk or impact assessment to understand how that binning works. But I think it could make a very big difference between the numbers that you get on the right-hand side for impact ratios, whether you bin it or you don't bin it. And so that's something that I think has to be looked at carefully. And I think it should be explicitly, the department should probably explicitly issue rules as to which they might prefer or which one they require. And then the other issue is statistical significance. So disparate impact, if you see impact ratios which are below the 4/5, so below 0.8, that is evidence of disparate impact. However, there is statistical significance criteria there to consider. And so for low numbers, like you might see here, there are some, so the Native American or Alaskan Native numbers in the female category are quite low. And so the uncertainty, the statistical uncertainty on that number is quite high. And so you see it's on the border of being showing evidence of disparate impact, but it will be even lower if you take the lower bound of that uncertainty, and it would be above it if you took the upper bound, right? And so typically statistical significance is taken into consideration here. And so that's part of the reason why I put the number of samples here, because you need to know the number of samples on the scoring in order to get some sense of that statistical significance. And so this is in the EEOC context. And so I just think that's something that should be taken into consideration. I think the raw numbers are a bit deceiving, and to give them context, the appropriate context, I think having some sense of the uncertainty or maybe even statistical significance right out might be important here. So we're coming up on a half an hour, and I'm gonna quickly go through what counts as an independent auditor. There's so much more to talk about, but I just want to have some time to answer a few questions. So what counts as an independent auditor? So this is the original definition, because it has to be an independent auditor that does this bias audit. So an independent auditor means a person or group that is not involved in using or developing the AEDT. So actually, no, take that back. This is not the original. This is the new proposed clarification. So the language in the text just says a bias audit is an impartial evaluation by an independent auditor. That's what the bias audit is. And so here they are clarifying what an independent auditor means: a person or group that is not involved in using or developing the AEDT. That is responsible for conducting a bias audit. So it's the person who's doing the bias audit, and they are not involved in using or developing the AEDT. So my quick take on this is that this does broaden the scope a little bit. The way it was written before, an impartial evaluation by independent auditor, there was a very narrow way to think about that, which was quite strict in terms of independence, which was good for us as an independent auditing firm. But I think this does broaden it a little bit, and it potentially opens up the door for internal audit functions, so internal to companies. So I think that does broaden the definition of independent auditor. Although you do have to be careful. So for number 2, don't forget impartial. That is in the original law. And so impartiality is still a requirement in the definition of a bias audit. And so you have to be careful to think very carefully about what impartial means. And so there are regulated industries that do have internal audit functions, model risk management, and in financial auditing. And they are quite independent. They report to a different, like directly to the board, for instance. And so that is a fairly robust process. However, that's a difficult process to get up to speed very quickly. And so just be careful, and don't forget that impartial is also part of the law. It's not just independent. Clarification is needed. So I think this is not helping. I think that this doesn't clear up the confusion for people. And so they need to be more explicit. Okay, so I'm going to stop sharing, and then I'm going to take a look at the Q&A. And I'll have to get my glasses on. Okay, so let me do the first one. It says, "Hi, I'm the head of an HR for a company. We use a third-party vendor to streamline our HR process, but I'm not sure if they use one of these AEDTs or not. There seems to be a lot of details to consider from the law. So how do we know if this law would apply to us?" That's a really good question. So I think when we gave our first seminar or webinar on this, our recommendation then was start now communicating with your vendors, and so definitely reaching out to your vendor immediately and getting clarification as to what do they actually use. And so there's no way of getting around that. There has to be some transparency there. And I think at this point, given the timeline, I would be quite forceful with demanding that some transparency around that. So it doesn't matter if it's proprietary, you can sign an NDA. You kind of need to know, and probably your lawyers need to know exactly what type of AEDT they're using. Is it AI? Is it machine learning? Could it be construed as being an AEDT under this law? And so that's something that I think you can't get around asking the vendor and getting answers quite quickly. Okay, so the next one, do you know if any companies, HR, banking, tech, have actually taken steps to become compliant with this law? Yeah, the answer is absolutely. And I mean, that's most of my day is spent talking to these companies, and I think most companies are aware of this, and so a number of them are taking really proactive steps to make sure that they either investigate further to find out whether they do fall under this under the law, per the first question. And if they already know that they're taking very serious steps to figure out how to get these bias audits done. There are also a lot of complications with notifying employees. The new rules act or potential employees and candidates or applicants. The new rules actually do some clarification around the notifications, which I think will make it a little bit simpler. For instance, getting things on conspicuously on your website seems to be something, and again, don't take my advice legally here, but it seems to be getting very clear language, very obvious notifications on your website or the platform is going to count as notification, so that the whole 10-day thing is not as burdensome as it sounded at first. And so yes, absolutely, people are taking this seriously, and given that we have 2.5 months before it becomes illegal to be using these tools without a bias audit, people are taking it seriously for good reason. Okay, so next one says, "Thank you, Shea. Do you know if the new rules say anything about the responsibilities for vendors?" Okay, so this is an interesting one. So the new rules do, they don't really explicitly say but it comes in the examples. And so maybe I'll share my my screen one more time. Okay, so let me go back to some of the examples. Okay, so here, even though they don't mention explicitly what role the vendors have, and that was one of our major comments on the first round, is that it's unclear exactly what vendors should be responsible for, and whether a vendor's audit, for instance, could apply to all of their clients, or has to be client by client based. And so here they do mention that the employer asks the vendor for a bias audit, and so quite explicitly they are, maybe not explicitly, they're sort of tacitly saying that a vendor can do a bias audit, or at least have a bias audit done, right? Because the vendor is creating it, so they are involved with the production or the producing this AEDT, so they themselves can't have it, can't do the audit, but they can have it done. The vendor uses historical data is collected from employers, and so the other interesting bit is it doesn't say from the employer. So it's implying, in my mind, at least to my reading, and this is my opinion, that there is some leeway for having, taking data that is not necessarily directly from the employer in question, but taking some representative sample. And I think, to be honest, I don't mind that. It depends a lot on what the vendor's tool is. But I think that there are cases where AEDTs you're looking for general statistical properties of that tool, and that many jurisdictions, like New York City, for instance, there are many jurisdictions that are going to look a lot like New York City, and it wouldn't be inappropriate to use data that was broader than that. And so that's my opinion. I think that does actually make a lot of sense. So employers do seem to be able to ask vendors to do this. And let's see, I thought there was another place where it became obvious, but I'm not seeing it now. So in any case, this is something that I think is possible, that vendors can do it. And I know I've talked to a lot of vendors, and they are feeling pressure from employers to produce something because they do know the tool better than the employers do. Now, that being said, the employers often have more access to demographic data, so the actual candidates who are applying to their jobs in their company, and so in some sense it's much easier to do the calculation, albeit with smaller numbers. Okay, so another one. Do we have any indication as to the enforcement of this law? Have the New York City authorities given any sign of who will enforce this and what kind of history of enforcement and budget they will have to do so? That's a really good question. I mean, I think it's clear the Department of Consumer and Worker Protection is the enforcement agency. The extent of the resources that they have to do this enforcement, I'm not aware of it. I think that one thing to keep in mind is that their job is made a lot easier by the presence of this public summary. And so while they, even if they're resource limited, they are able to just go look at the biggest employer who's in New York and see whether they've published something or not, and figure out to what extent they feel like that published summary is something of integrity or has is compliant with the law. And so I think there's a lot of risk here, and I think that resources will be a problem, because there are a lot of companies that are not based in New York, but do hire out of New York using AEDTs that are going to fall under this. And to the extent that they are able to sort of proliferate out any sort of legal action against these companies, I don't know. But it's a good question, and it, come January 1st, we'll find out. But that is a good question. So I think that's it for questions. So let's, unless someone has another one, I'm happy to sort of sum this up and and say that there's a lot more here to digest. And so next week will be the hearing on this. I'm hopefully I'll get a chance to speak, but if not, BABL is submitting public comments on this, and I think there's a long way to go to get full clarity on a lot of this. And I think in some sense the new rules have added confusion in some areas, but has also been very explicit and useful in other areas. If this vendor issue, for instance, was something that was we were totally in the dark about whether it would be acceptable if a vendor were to have an audit done and an employer to use that audit. I think there's a lot of risk in that, and that there still needs to be some careful thinking. But in any case, we'll be talking about this for a while now. So we're going to do this every week. It's not always going to be about New York, and in fact, there are other regulations like the EU AI Act, the Stop Discrimination by Algorithm Act in DC, California, proposed regulations of the similar type in California. And so we're going to just talk about algorithmic auditing, AI auditing, and risk in general every week. So thank you for joining me. If you want to follow up, my email is shaybrown@bableai.com, and so feel free to reach out to me or any other member of BABL if you have any questions. And thank you for showing up.